It's sometimes the case that the member firm, even though they've registered with the SEC, so they're a new firm, they're not actually engaged in business during those first 6 months. And if that's the case, then FINRA is allowed another 6 months to conduct the exam. Within critical function number 3, we have the proper handling of disputes. Arguments. In the securities industry, what do we argue over? Money. Yeah. So FINRA has an arbitration procedure that must be followed. So it's 12,000 and 13,000 series. The Code of Arbitration exists to prevent lawsuits. So firms can't sue each other. Reps can't sue their firms. Firms can't sue their reps. Firms can't sue their customers. Customers can't sue their firms, so long as we all agree to arbitration. Now, as a rep, as a firm, you must agree to arbitration. Generally speaking, as part of the account opening process, we're going to have what's called a pre-dispute arbitration agreement that will basically say to the client, by being our client, you agree to not sue us later. If you ever disagree with us, you agree to go through the arbitration process. So the Code of Arbitration does not contain any sanctions or penalties. It is used to settle disagreements and misunderstandings. Decisions reached through arbitration are final and binding and cannot be appealed. So the Code of Arbitration. Decisions are final, binding, not subject to appeal. Under FINRA Rule 2268, when a customer's account agreement includes a pre-dispute arbitration clause, the following must occur. The clause must be highlighted, and the clause itself must be immediately preceded by the following disclosures. So this has to be before the pre-dispute arbitration clause in a customer's new account form. This agreement contains a pre-dispute arbitration clause. By signing an agreement, the parties agree as follows. All parties to this agreement are giving up the right to sue each other in court, including the right to a trial by jury, except as provided by the rules of the arbitration forum in which the claim is filed. Arbitration awards are generally final and binding. A party's ability to have a court reverse or modify an arbitration award is very limited. The ability of the parties to obtain documents, witness statements, and other discovery is generally more limited in arbitration than in court proceedings. The arbitrators do not have to explain a reason for their award. So, arbitrators do not have to explain the decision, which is kind of a funny feeling, to explain the decision. Unless, and this unless is important, I definitely need you to know this, unless all parties jointly request a written explanation at least 20 days prior to the first hearing date. So it is possible to get an explained decision. It's possible to get an explanation if we ask for it at least 20 days prior to the first scheduled hearing date. And that wasn't always the case historically. So I think that that's a great change in the arbitration rules. Both parties have to request the written explanation. Going on with what must be found before the pre-dispute arbitration agreement, The panel of arbitrators may include a minority of arbitrators who were or are affiliated with the securities industry. The rules of some arbitration forums may impose time limits for bringing a claim in arbitration. In some cases, a claim that is ineligible for arbitration may be brought forward in court. Customers must acknowledge receipt of a pre-dispute arbitration agreement in writing. So customers must acknowledge receipt in writing. Of the pre-dispute arbitration agreement. It's usually found within the new account form. So they sign something saying that they've seen it, that they've received it. Firms must provide to the customer a copy of the signed agreement within 10 business days of a customer's request. So if a customer asks for a copy of the pre-dispute arbitration agreement, the broker-dealer has 10 business days to provide a copy. To the customer. Arbitration does have a statute of limitations. The statute of limitations for a dispute or controversy that is eligible for arbitration is 6 years of its occurrence. So statute of limitations, I would definitely know, statute of limitations for arbitration, 6 years. So if something happened more than 6 years ago, nobody can file for arbitration regarding it. It is past the statute of limitations. Under the Code of Arbitration, if you're asked to answer a statement of claim, you're called a respondent. If you're presented with a statement of claim, you have 45 days from receipt of the statement of claim to respond. "45 days to respond." Now, anything that's eligible for arbitration may, instead of arbitration, be mediated. Mediation is entirely voluntary. So mediation is kind of a step before arbitration. If it's in mediation and either of the parties decides they don't want to mediate, they can drop out of mediation and go to arbitration instead. Either party may withdraw from mediation any time before a written statement has been reached. When we're in arbitration, the decision is binding. But in a mediation, the mediator acts impartially in an attempt to settle the dispute and has no authority to resolve the issue. So arbitrators make decisions. Mediators just facilitate the process of hopefully reaching a mutual agreement. If a matter goes to mediation and the mediation fails, it is always still eligible for arbitration. Now we need to know about what is called simplified arbitration. Simplified arbitration. Now, first off, how much money can we be arguing about? Unlimited amounts of money, right? So arbitration can be used to handle any type of dispute, no matter the amount of money involved. Simplified arbitration, however, is only used when the amount of money in dispute is $50,000 or less. I would absolutely know this. Or less. So any amount of money is eligible for arbitration, but if the amount of money in dispute is $50,000 or less, we go through a process called simplified arbitration, where there is one single arbitrator. The one single arbitrator makes a binding decision within 30 business days. One arbitrator. Binding decision within 30 business days. So simplified arbitration is the same rule no matter who is involved in this dispute. A representative, a member firm, a customer, it doesn't matter. Simplified industry arbitration is the same no matter who's involved in the dispute. So for sure a question, if not 2 or 3, on that topic. So that one's easy. If the amount of money in dispute is over $50,000 up to $100,000, then we have another set of rules. So the amount of money in dispute is over 50 up to 100. So we're no longer in simplified arbitration anymore. Remember, simplified was up to $50,000. Now, for all of these, whether or not the case involves firms, brokers, registered reps, or investors, there's one arbitrator unless the parties agree to 3. One arbitrator unless the parties agree to 3. The question, however, is the arbitrator someone from within the securities industry, or are they what we call a public arbitrator? When the case involves firms, it is someone from within the industry, which we call a non-public arbitrator. Non-public. So if it involves firms, it would make sense that you would want the arbitrator to have real-world experience with how does the securities industry work. So one non-public arbitrator. When the case involves representatives or clients, then we have public arbitrators. Public arbitrators. So these are the rules when this is kind of the middle level of disputes. So too big to be simplified industry arbitration because it's over 50, up to $100,000. What if the money in dispute is over $100,000, or if it's for an unspecified amount? No matter what, whether or not the case involves firms, brokers, or clients, we will have, when the amount of money in dispute is over 100,000, 3 arbitrators. Over 100,000 or unspecified, 3. It's called panel arbitration. 3 arbitrators. Now, when the case involves firms, just like when the amount of money in dispute was over 50 up to 100, when it's involving firms, the arbitrators are non-public arbitrators, just like before. So with securities background, non-public arbitrators. Now, it is 3 arbitrators unless the parties agree to 1. Unless agree to 1. So that's the opposite of the way it was before. Before it was 1 unless they agreed to 3. Now it's 3 unless they agree to 1. So this is the rule for firms, non-public arbitrators. When the case involves a broker or a registered representative, still 3. One of those 3 is non-public and 2 of them are public. So the only time they can agree to 1 arbitrator when the amount of money in dispute is over 100,000 is the firm. When the case involves reps, then we always have 3. 1 non-public, 2 public. If the amount of money in dispute's over $100,000 and involves a client, it's 3 arbitrators. But how these arbitrators are selected is a little complicated. I'll show you. They may be either public or non-public. Now think about this for a second. If you are a customer, right, you're a client, who do you think is going to be more on your side? Who do you expect might be more sympathetic to you? A non-public arbitrator, so someone in the securities industry, or a public arbitrator? What would you think? Yeah, a public arbitrator, FINRA has found, will find more favorably for the client. So, how does the procedure work when the amount of money in dispute is over $100,000 and it involves a client? What ends up happening is FINRA will provide the parties with 3 lists. So this is when the amount of money in dispute involves clients and it's over $100,000. So the parties involved get 3 lists, and on each list is 10 arbitrators. So we have a list of 10 non-public arbitrators. We have a list of 10 public arbitrators. And we have a list of 10 chair qualified, because we have to have one person that serves as the chair. They're the one who would write the written explanation of the decision. Chair qualified public arbitrator. So the parties involved include a client, right, a customer, an investor, and a firm, or a customer and a rep. So the parties involved are given these 3 lists. So no longer do the parties choose a panel composition method. They used to do that historically. Recently it's changed, and this is the way it's handled now. So each party gets 3 lists, 10 persons each. From the list, each party may strike from this list of 10 chair-qualified public arbitrators 4. So the client's attorney could strike 4 chair-qualified public arbitrators. The registered rep's attorney could also strike 4. May strike an additional 4 from the list of 10 public arbitrators. From this last list, may strike any or all. So think about that for a second. So we're basically saying to the parties involved, so the client, the firm, the client, the rep, you can get rid of, and who's most likely to want to do this is the client, all non-public arbitrators, all of them. And then of what's left, FINRA will select, of the ones that you didn't strike, and of course the other party gets to strike them as well, we will select 3, 1 chair qualified and 2 not chair qualified arbitrators for this proceeding. So I know it's kind of a long story as to how it works nowadays, but FINRA did some exhaustive studies about the composition of the panel and what kind of decision they reach, and they were able to find, like I said before, that when it is public arbitrators, the decision is more likely to be in the better interest of the investor. So we're really, we being FINRA, trying to encourage that to be the way that the panel is comprised. Remember, there are no penalties involved in arbitration. Arbitrators simply determine who is right and who is wrong, awards the winning party the amount due. All monetary awards must be paid within 30 days of an arbitration decision. Arbitration awards must be paid within 30 days of a decision. All awards and details of the arbitration claim are made available to the public. We talked about FINRA's Code of Arbitration does allow, if both parties jointly request an explained decision, at least 20 days prior to the first scheduled hearing date. So this explained decision is a fact-based award stating the general reason for the arbitrator decision. Inclusion of legal authorities and damage calculations are not required. It is the chairperson of the panel that is responsible for writing the explained decision. So I would expect a handful of questions on arbitration, most definitely. The 14,000 series is the Code of Mediation procedure. Now, I already mentioned a little bit about mediation. Mediation is voluntary. Arbitration is mandatory. Mediation is voluntary. There is a National Arbitration and Mediation Committee that is required to consist of no fewer than 10 and no more than 25 members. At least 50% of the National Arbitration and Mediation Committee are required to be non-industry members. The National Arbitration and Mediation Committee meets as frequently as necessary, but must meet at least once every year. This board appoints a director of mediation to administer mediations under the code. The code is the Code of Mediation, and the board is the board of directors of FINRA's dispute resolution. In order to go through mediation, it requires written agreements of all parties. No party may be compelled to participate in a mediation or to settle a matter by FINRA. Entirely voluntary. If all parties agree, any matter that is eligible for arbitration or any dispute related to such matter may be submitted to mediation instead. The director has the sole authority to determine if a matter is eligible to be submitted for mediation. In a mediation, parties may represent themselves. Parties may be represented by an attorney, which is the same for arbitration as well. Parties may be represented in mediation by a person who is not an attorney, unless state law prohibits that, or that person is barred from the securities industry, or the person is barred from the practice of law. So you may be represented in a mediation by a person who is not an attorney, unless the person was an attorney and now can't be. That would not be allowed. No mediator may serve as an arbitrator of any matter pending in FINRA arbitration in which he or she served as a mediator. Nor may the mediator represent any party or participant to the mediation in any subsequent FINRA arbitration relating to the subject matter of the mediation. Who can be a mediator? The mediator may be selected by the parties from a list supplied by the director, with the director's approval upon receipt of the party's joint request from a list or other source that the party chooses, or by the director if the parties do not select a mediator. So the director can choose a mediator for them. There are ground rules for mediation. The ground rules are intended to be the standards of conduct for the parties and the mediator. We already know mediation is voluntary. Any party may withdraw from mediation at any time prior to the execution of a written settlement agreement by giving written notice of withdrawal to the mediator, the other parties, and the director. The mediator acts as a neutral, impartial facilitator, shall not have any authority to determine issues, make decisions, or otherwise resolve the matter. In a mediation, the parties must agree to attempt, in good faith, to negotiate a settlement of the matter. Mediation is intended to be private and confidential. There are filing fees associated with cases in mediation. There are mediator charges, travel expenses. Each party in a mediation is required to deposit its proportional share of the anticipated mediator charges prior to the first mediation session. So mediation, private, confidential, we go into it, we agree to try to get to a solution. And we can always withdraw. Arbitration, mandatory. Mediation sounds more fun, I think. FINRA Rule 2080. The rule is about obtaining an order of expungement of customer dispute information from the CRD system. Members or associated persons seeking to expunge, which is the fancy way of saying remove, information from the CRD system arising from disputes with customers must obtain an order from a court of competent jurisdiction directing such expungement or confirming an arbitration award containing expungement relief. Members or associated persons petitioning a court for expungement relief or seeking judicial confirmation of an arbitration award containing expungement relief must name FINRA as an additional party and serve FINRA with all appropriate documents. It is possible, however, that FINRA may waive the obligation that FINRA be named as a party if FINRA determines that the expungement relief is based upon affirmative, judicial, or arbitral findings that the claim, allegation, or information is factually impossible or clearly erroneous, that the registered person was not involved in the alleged investment-related sales practice violation, forgery, theft, misappropriation, or conversion of funds, or the claim, allegation, or information is false. It is possible that people will go after you for wrongdoings that you did not do wrong. So this is a way in which you can get those out of the CRD system. FINRA Rule 4513 has to do with records of written customer complaints. Written customer complaints. Broker-dealer firms are required to keep records of written customer complaints for 4 years. That has to do with FINRA will conduct examinations of all broker-dealers on an interval to be determined by FINRA, but no less frequently than once every 4 years.